Welcome to DTS Attorneys. Today we're addressing a sore subject for a lot of purchasers and sellers when it comes to transferring property, and that is delays in the transfer process. First up, Riyar, will you mind explaining what delays are outside the control of parties?
Yes, as you mentioned, Arnold, it is really a sore subject and we're trying to avoid that as far as possible. Now, the delays outside the control of any parties are the typical ones, such as the deeds office, which might experience a backlog, where matters run for longer than the 10 days allowed for in the Act, or where SARS is experiencing either system errors called backlogs, where we wait longer than the required 21 days for our transfer duty receipts, and also the municipality, where you might experience undue delays in obtaining clearance figures from the municipality, and also the certificates once you have paid. Those delays can generally not be avoided, and although we try our best to following up using our contacts, if these delays are encountered, it generally is a fait accompli. There's not much you can do about.
Okay, so unfortunately those delays are outside your control. Are there any delays that clients can cause to the process?
Yes, it saddens me to say that unfortunately we experience more delays caused by the buyers and the sellers in the process. Now, the typical delay if you start the process is to obtain information from your parties. Your seller must provide you with his income tax number, with his title deed if it is in his possession, his bank account number reflecting his bond account if a property is bonded, and so forth. Without that information, we cannot move forward. Then the second round is once we've obtained all the information and are ready for signature, then the parties must come forward and sign as soon as possible. Yet again, through human error or inaction, the signing process might be delayed if people do not pitch for their appointments, or if they unnecessarily delay making the appointment or confirming their appointment with a signing attorney.
Can there be any delays caused by persons not having title deeds ready?
Yes, the problem is specifically if we don't know that the title deed is lost. If a party tells us at day one, when we receive an instruction that is lost his title deed, we can immediately commence the process, and in the end, the lost deed application will run parallel to the transfer process, and he should not experience any delays. The sad part is where the client tells us that he's got the title deed, he will bring it in. We follow up a week later, he says he's still searching. Another week later, he's still searching. And then at the end, when we are ready to lodge, the client comes and tells us, no, I've lost my title deed. Then you have lost out on about 3-4 weeks of the transfer process.
And what's the rule of thumb with regards to getting compliance certificates sorted out?
Yes, there's basically 3 options. The one is that the seller will sort out these certificates himself, or the estate agent will arrange for the certificates, or the attorney will arrange for the certificates. Yet again, the party must make up his mind at the time of instructing the attorney to do the transfer. Then, if it's our responsibility, we will immediately arrange it, and we will make sure that the certificates are in hand timeously. Unfortunately, again, people often say, no, I will do so. We follow up. And then at the very last day, we're ready for lodgement. They say, oh, no, we didn't get to it. Will you please do it? And then you will find a delay. So if you see that you're not going to get to it, just request to attorney to attend to it immediately.
Okay, so just to summarize, what are some key takeaways for clients just to make sure that they don't delay the process themselves?
I think the key takeaway is to, firstly, when you sell your property, when you list your property, make sure that you have your title deed in hand. If you've got an old bond, make sure that you have the bank details reflecting that bond account number, and speak to the attorney. Also, it might, if you know that your property is very old and there's going to be a lot of electrical work to be done, for example, obtain the quotations from various contractors right before even selling the property, so that there's sufficient time to choose between the quotations and also to instruct the work to be done.
And let's not forget the importance of communication, especially if you know you're planning a holiday and going to be outside of contact for 3 weeks or 6 weeks, to make sure that the attorneys have adequate time to prepare the documents and can make arrangements before you leave the country or go on your holidays.
Yes, specifically if you are leaving the country, make sure that someone in the city where your property is situated has a power of attorney to sign the transfer documents on your behalf. It's a whole topic for another day, but unfortunately, get signed documents over ECs, it's costly and time consuming.
Thank you very much, Ria. If you have any further questions, please feel free to contact DTS Attorneys.